The executive has no right, in any case, to decide the question whether there is or is not cause for declaring war. When James Madison said, "in any case," he meant it. No exceptions and no loopholes. But today, almost every politician and so-called expert wants you to believe that a president can unilaterally take us to war just as long as they don't call it a war. But that's not what the Constitution says. That's not how the founders understood it, and that's not how Presidents Washington, Adams, Jefferson, or Madison followed the Constitution in practice. So in this episode, you're going to learn the truth about what the Constitution means by declare war. But first of all, before getting to that, welcome, and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, March 17th, 2025. And for something like this, we got to start out with the text of the Constitution. Article 1, Section 8, Clause 11. War powers. Congress shall have power to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. And here are just a handful. There are many, many others. A handful of examples of how the founders viewed this power. Let's start with Thomas Jefferson. Congress alone is constitutionally invested with the power of changing our condition from peace to war. So many people will tell us like, oh, this is just about Congress having a power to issue a statement. But there is a practical result of this, that whatever statement they may issue, it's about changing our condition from peace to war. James Wilson, one of the first associate justices of the Supreme Court, a leading legal expert of the time, a top framer in Philadelphia, put it like this: "This system will not hurry us into war. It is calculated to guard against it. It will not be in the power of a single man or a single body of men to involve us in such distress. For the important power of declaring war is vested in the legislature at large. This declaration must be made with the concurrence of the House of Representatives." Alexander Hamilton agreed. He said the legislature can alone declare war, can alone actually transfer the nation from a state of peace to a state of hostility. And James Madison, writing in Helvidius number 1, points out that a declaration of war is purely a legislative function. It can't, by its nature, be executive. And he summed that up with this: "In the general distribution of powers, we find that of declaring war expressly vested in the Congress, where every other legislative power is declared to be vested, and without any other qualification than what is common to every other legislative act." Now, Madison thought, here's the father of the Constitution, he told us that this is the wisest part of the Constitution, putting the power to declare war in the hands of Congress rather than in the executive branch. He said, "In no part of the Constitution is more wisdom to be found than in the clause which confides the question of war or peace to the legislature and not to the executive department." I covered Madison's view on this in much more detail in an episode last fall, Constitution, the wisest part, according to James Madison. That'll be included in the show notes over at 10thamendmentcenter.com/path to liberty. Now, the founders also told us over and over and over just why they separated these powers. They didn't want it in the hands of a single person, as James Wilson was pointing out. Madison put it like this: "Those who are to conduct a war cannot, in the nature of things, be proper or safe judges whether a war ought to be commenced, continued, or concluded." And they wanted to separate that power to prevent the declaring of war just to wage it, because that's what a single person could do. George Mason in the Philadelphia Convention said he was for clogging rather than facilitating war, but for facilitating peace. And if you think about the context of that time, it's pretty easy to understand why. The founders, the old revolutionaries, just a few years earlier, had fought a long, bloody war to free themselves, to secede from an empire where that decision was in the hands of one dude, a single person. And here from St. George Tucker, he said, in England, the right of making war is in the king. In Sweden, it was otherwise after the death of Charles XII, until the Revolution of 1772, when from a limited monarchy, Sweden became subject to a despot. With us, and that's the system, where the people of the several states are sovereign, they hold final authority. From them flow all powers, and it is delegated to just their agent. Government isn't a master, it is merely an agent of the people of the several states, of the people. We, the people, with us, the representatives of the people, have the right to decide this important question. If the executive makes that decision, again, it's more like a monarchy that they escaped from, that they seceded from, that they risked their lives to leave. Here's James Madison in a letter to Thomas Jefferson, really hammering this home. The Constitution supposes what the history of all governments demonstrates, that the executive is the branch of power most interested in war and most prone to it. It has accordingly, with studied care, vested the question of war in the legislature. So not only was it the wisest part of the Constitution, according to the father of the Constitution, he also pointed out that they put a lot of thought into this. Studied care put that question of war or peace in the legislature. Pierce Butler, in the South Carolina legislature, in a speech in early of 1788, he pointed out that there were some people who did want to put this in the hands of a single person. Maybe it was Pierce. He said some gentlemen were inclined to give this power to the president, but it was objected to pretty vehemently as well. I'll say that. He said, as throwing into his hands the influence of a monarch, having an opportunity of involving his country in a war whenever he wished to promote her destruction. They all understood, because they were students of history, unlike most of us today, but all of us here, well, most of Americans today, those of us here, we're certainly studying history, doing our best to learn lessons from that so we don't repeat them over and over and over. But the founding generation, they were really good students of history, and they understood that giving this kind of great, massive, and deadly power to just one person did not have very good results. And that's how the future Chief Justice John Jay put it in Federalist Number 4. He said, "It is too true, however disgraceful it may be to human nature, that nations in general will make war whenever they have a prospect of getting anything by it." But Jay continued pointing out that it's even worse, again, when the power is concentrated in one hand or in a single person. Nay, he said, that absolute monarchs will often make war when their nations are to get nothing by it, but for purposes and objects merely personal, such as a thirst for military glory, revenge for personal affronts, ambition or private compacts to aggrandize or support their particular families or partisans. We'd call them lobbyists these days. So that brings us to, well, doing our best to understand what the words declare war mean in the Constitution. And as a refresher, as we get to this, that means we have to understand how the ratifiers, the people who gave the Constitution legal force, understood those words, because that's how you understand a legal document, especially an 18th century legal document. Thomas Jefferson put it like this: on every question of construction, carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of what they usually do today, trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. And James Madison, of course, absolutely agreed with this take. He said, "I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution." So let's get right into it. We'll start out with the word war. And Mike Meharry writes that today, most people think only an all-out war, basically a full-scale invasion against another country, counts as war under the Constitution. In their view, smaller-scale military operations fall short of the war threshold and therefore don't need congressional authorization. Now, this isn't a war. So Congress, we could just do an end run around them. We'll just keep it limited. I guess you could wage like a limited war for a week, pause for a day, start another one, pause. I mean, that's kind of how they approach it. It sounds absurd, but that's really what it means in practice. And Mike writes that as constitutional scholar Rob Natelson has noted, the founders didn't actually make this distinction. He wrote, founding era dictionaries and other sources, both legal and lay, tell us that when the Constitution was approved, the word war consisted of any hostilities initiated by a sovereign over opposition. A very typical dictionary definition was, quote, the exercise of violence under sovereign command against such as oppose. That's from Barlow's Law Dictionary, 1772 to 73. I got a couple other examples of some very popular, widely read dictionaries of the time. Here's Thomas Sheridan's Complete Dictionary of the English Language, published in 1789. He said, war is the exercise of violence under sovereign command. You notice there isn't like a caveat about the amount of violence or how widespread the violence it is. It's just the exercise of violence under sovereign command. Or Samuel Johnson's 1773 edition of his Dictionary of the English Language, maybe the most famous one from the time. War may be defined the exercise of violence under sovereign command against withstanders. Force, authority, and resistance being the essential parts thereof. So again, violence under sovereign command against opposition. No caveat for the amount of violence, the scale of violence, how much is used, how long it's used. No caveats like we hear about today. Now, President George Washington also understood it this way and referred to an undeclared war in 1795, back to 1793 as well, with the Creek Nation as the predatory war between the Southern Indians and the southern and southwestern frontiers of the United States. He's not talking about a predatory kinetic action or police action by the Creek in his letter to Timothy Pickering. It's a predatory war. And previously in his 5th annual message to Congress, he said this, an anxiety has been also demonstrated by the executive for peace with the Creeks and the Cherokees, and offensive measures against them prohibited during the recess of Congress. It is with Congress to pronounce what shall be done. How about John Adams, who as president, well, most experts will tell you he was not waging a war against the French. It was just what they call today the so-called Quasi war. It's not really a war, so he didn't need Congress, but this is also just a total lie. And Adams himself disagreed with the notion that this wasn't a war. I don't think he ever made the case that it wasn't a war. He said in a letter to Thomas Jefferson years later, we were then at war with France. And he said the same thing during the war with France in a letter to John Marshall. This is in 1800. Congress, he said, has already, in my judgment, as well as in the opinion of the judges at Philadelphia, declared war within the meaning of the Constitution against that republic under certain restrictions and limitations. And we'll get to that a little bit more in just a moment. Here's Mike Meharry discussing James Madison's view on this as well. He said, as president, in a special message to Congress in 1812, President Madison enumerated U.S. grievances against Britain. He asserted that impressments, basically they were kidnapping people on the sea, blockades, and other aggressive measures, amounted to a declaration of war against the United States. So the British were being aggressive. They were violating our rights, our property. They were kidnapping people, running blockades, another act of war. These types of things are all sanctions. All that type of stuff is an act of war to the founding generation. And Madison said that even though Britain had not formally issued a document that says we're going to war with the United States, he said, well, they are already at war with us. And that's what Mike said. Even though the British had made no official pronouncement of war against the U.S., much less issued a formal declaration, Madison believed their actions spoke louder than words. And here's how Madison put it in his special message to Congress, his war message of June 1st, 1812. He said, "We behold, in fine, on the side of Great Britain, a state of war against the United States, and on the side of the United States, a state of peace towards Great Britain." It's not like everything was peaceful and awesome. He's talking about the technical legal definition of whether they were going to war, whether he as president could exercise the powers of war that were delegated to him as commander-in-chief. But that decision first had to be made by Congress, whether or not they were going to stay on the defense or if they were going to go on the offensive. And he said, whether the United States shall continue passive under these progressive usurpations and these accumulating wrongs, or opposing force to force in defense of their national rights, is a solemn question which the Constitution wisely confides to the legislative department of the government. So Congress responded with a declaration of war. They didn't say, hey, they're already at war with us. You can just do whatever you want. Why are you even asking us? That wasn't even a question. Still had to get approval from Congress, even in that situation where there was an active, ongoing war being waged on the U.S. by Great Britain. They were continually doing all kinds of acts of violence and threatening more, and still needed congressional approval. First of all, before getting deeper into this, I want to point out that all of the original source documents that I'm mentioning in this episode, plus the articles, etc., other episodes, they'll all be linked to in a blog post over at 10thamendmentcenter.com/path-to-liberty. It's all spelled out. Alan Mosley gets it organized, and you'll see in that blog post a show links section where generally in the order that I go through it in the episode, you'll be able to see all the reference links so you can read and learn more in context on your own time. I really am just scratching the surface. I know I'm squeezing a lot of info into this one. This is a huge, huge, important topic. And I encourage you to check out the blog post. I'll get it published a couple of hours after this live stream is over at 10thamendmentcenter.com/path-to-liberty. Now, here's Chief Justice John Marshall. Not necessarily our favorite dude, but here he is in 1801 agreeing that a limited military action is still a war under the Constitution. He said, the whole powers of war being by the Constitution of the United States vested in Congress, the acts of that body can alone be resorted to as our guides in this inquiry. Congress may authorize general hostilities, in which case the general laws of war apply to our situation, or partial hostilities, in which case the laws of war, so far as they actually apply to our situation, must be noticed. Now, notice he did not say if it's just limited or partial hostility, the president can authorize it. None of the founders thought that was what was authorized under the Constitution. Now, here from Sai Prakash, he says, the more general point on this is that the Constitution provides that Congress may decide what type of war America shall fight. Otherwise, the people are not the top of the food chain. If some person in government decides what the people are going to get, that's the system that the founders fought that long, bloody war to get away from. This is supposed to be asserting that the people of the several states, they are in charge. They hold sovereignty. So on one of the most important questions, if not the most important question, war, it still needs to be up to the people of the several states to determine what type of war they're going to fight, whether they're going to fight one at all or not. At one extreme, writes Prakash, Congress may grant letters of marque and reprisal only to individuals with actual grievances against another nation. This is the most constrained form of warfare, authorizing the narrowest acts of hostility. At the other extreme is a general warfare, like just a pure declaration of war with no limitations. And that's Congress requiring the commander-in-chief to commit any and all hostilities against the enemy, and with Congress authorizing the president to issue general letters of marque and reprisal to any ship captain who wishes to fight for country while also enjoying the possibility of a handsome profit. No further congressional escalation is possible. Those are the two extremes. Either a very limited, individual-based mark and reprisal from Congress, or a total declaration of war where Congress can't take it any further. The executive is really required to go all out in that situation. Here's Justice Samuel Chase in 1800. Congress is empowered to declare a general war, or Congress may wage a limited war, limited in place, in objects, and in time. If a general war is declared, its extent and operations are only restricted and regulated by the jus belli, forming a part of the law of nations. But if a partial law is waged, its extent and operation depend on our municipal laws. And going to war in and of itself, literally just launching one missile in and of itself, is a declaration of war. No one on earth would ever think that if a bomb landed on your country, that someone else was not waging some form of war against you. You're happy if it's not a lot, of course, but it still is war. No one would think if another nation launched a missile and hit the United States that that was not warfare. And the founders understood it this way as well. You can go all the way back to people like John Locke and even much further back to get this type of a take. Here he is. Here's Locke in his second treatise. The state of war is a state of enmity and destruction. And declaring by word or action puts him in a state of war with him against whom he has declared such an intention. So again, going to war in and of itself is a declaration of war, but the founders really wanted to follow the law of nations, to do it the right way if you had to. And they get that primarily from Vattel, but some other people as well. And they saw that basically a requirement that you're supposed to announce it before you start that war. You're supposed to announce it. Now, Vattel himself, and I'm not going to get really into detail here, but I just want to point out that Vattel himself said you didn't have to announce it way in advance because you're not supposed to give away your intentions so you lose. If you need a strategic advantage, he basically gave an example like you could wait until you're lined up and in position, maybe even into their territory, and then issue the declaration. And that's still cool under the law of nations as understood by the founding generation, the old revolutionaries. And the founders saw the Constitution structure as strictly following these rules of war from Vattel in his Law of Nations. I think this is 1758 edition here. Here from Book 3, Chapter 4, which is called Of the Declaration of War and War in Due Form. Vattel wrote this, "But no person being exempted from his duty for the sole reason that another has been wanting in his, we are not to omit declaring war against a nation previous to commencement of hostilities, because that nation has on a former occasion attacked us without any declaration." Translate, the TLDR is, just because they did it. This is like the 2-year-old, maybe 4-year-old argument. Well, my friend did it, why can't I? My enemy did it, why can't I? That's the argument a lot of people make. Oh, well, they attacked us. Well, we don't have to follow it then. We can just do whatever we want. But for Vattel, and this is what the founders really held strictly to, if another nation decides to violate these principles of the law of nations on declaring war, that does not give you a right to violate those same principles when you respond. He said that nation in so doing has violated the law of nature, and her fault does not authorize us to commit a similar one. Again, this is a childish argument to say, well, they did it, so we can just do whatever we want. In other words, the people who don't declare war are actually the bad guys. And in many situations, especially in modern times, they're all the bad guys. Here, back to Prakash. He said, although declarations of war, he's explaining what purpose they serve beyond this law of nature from the law of nations, from Vattel, the purpose of explaining it just being morally correct. He said, although declarations of war could serve many related functions, the principal function of a declaration was that it announced that a nation had chosen to wage war in order to resolve its differences with another nation. And Vattel talks about this as well. He really felt that unless you really needed to for a strategic advantage, you should say, hey, we're going to go to war with you, and then maybe wait a little bit if you can and see if the other side backs down, or you can come to an agreement and then you can still have peace. You still have a chance for peace. Prakash continued, declarations would serve to notify the enemy, one's own nationals, and the rest of the world that one nation had decided to wage war on another. But he said, because the decision to wage war was itself a declaration of war, the nations at war had declared war in the very act of going to war. Again, just going to war, launching a missile, an airstrike, drone strike, whatever it may be, special forces invading someone else's country, shooting a bunch of people, handful of them. These are all acts of war and can be responded to in kind. And if we think about the Constitution, we have to first understand again that the federal government is merely an agent of the people of the several states. It's not a ruler. It's not a master. So even on war powers, there are rules to ensure that this is how things are supposed to remain. And Mike Meharry made this important point. If left to his sole discretion, a president might not respond to aggression when the people want to, and vice versa. So what if someone's attacked? I think we've seen these types of things in recent times. If another nation is being aggressive against the United States and the executive branch has no backbone, maybe they don't want to do anything about it. And if it's just his decision, you're leaving in the hands of one person who's possibly just a total weakling. And that's why the decision is up to the people of the several states. And Mike says in the constitutional system, it's simply not his call. After all, ultimately, government is merely the agent of the people of the several states. So a president might not want to respond to aggression at all, but it isn't his decision. And Prakash made a very similar observation here as well. When a nation attacks another nation, the victim always has choices. Will the victim respond in kind with full-scale war? Will it pursue rather pacific measures, staying on defense, such as a request for negotiation? Or will it pursue a third course of defensive measures, coupled with a stern ultimatum? So there's choices. These are examples of choices. And again, if the people are the top of the food chain in the constitutional system, it is their representatives who are going to make that choice, not one single dude, period. And defensive measures to the founders, if we're thinking about staying on that third course, as Prakash described it, they were very, very limited. Thomas Jefferson explained it like this. Again, Congress alone is constitutionally invested with the power of changing our condition from peace to war. And because of that, I have thought it my duty to await their authority for using force in any degree which could be avoided. And he explained how that played out in practice. This is in 1805. I have barely instructed the officers stationed in the neighborhood of the aggressions to protect our citizens from violence, to patrol within the borders actually delivered to us. They can't go outside the borders, and not to go out of them, but when necessary to repel an inroad or to rescue a citizen or his property. Anything going beyond that is considered a reprisal, and reprisals are acts of war, and that means Congress has to make that decision. I'll even get Alexander Hamilton on that in just a moment. And again, in 1792, there was all kinds of warfare going on in George Washington's terms. Cherokee tribes in 1792, I think it was 5 of them, issued a formal declaration of war. And it was considered very unusual, but they certainly did it. And then on top of it, they were waging that war. And in response, President George Washington, through his Secretary of War, Henry Knox, held the line on sticking to the line of defense. Here from, whose article is this? Is this me or Meharry? This was my article on George Washington and war powers. Documents show that it was the unanimous opinion of Secretary of War General Henry Knox, along with Secretary of the Treasury Alexander Hamilton and Secretary of State Thomas Jefferson. Fascinating to see all 3 of those guys unanimous in their view that despite ongoing attacks and a formal declaration of war on the United States by Cherokee tribes, quote, all measures of an offensive nature be restrained until the meeting of Congress, to whom belong the powers of war. So the way this played out in the Washington administration was he would tell his commanders on the front line, If they do an incursion into our territory, you can just crush them. But you can't go out hunting for them. That's going on the offense. And he kept getting asked for that type of authority over and over and over. He said no. He asked Congress. Sometimes they said no. And then he kept pushing, and eventually he'd say yes. And only after Congress said yes would they go on what George Washington called offensive expeditions. Here back to this article from my article, Knox then informed Governor Blunt that he could deal with incursions into his territory, but it could only take those defensive measures. Further action could only be taken under the authorization of Congress. Quote, this is again from Secretary of War General Henry Knox. As you have ample powers to call forth such portions of the militia of your government for its defensive protections as you shall judge occasions to require, no further steps can be taken at this moment. And he explained why. He said, this is intended to restrain any expedition against the Indian towns, but all incursive parties against your frontiers are to be punished with the greatest severity. So again, if they cross into our territory, you can go ape on them, just crush them, but you can't go chasing after them. Only if Congress says you can do that. That's President George Washington. And the Adams administration did the same in that so-called Quasi war, which John Adams understood was really a war. And by 1797, I think it was, maybe middle of 1797, the French had already seized. They didn't just kind of rip people off, but they seized 300 American ships, 300 American vessels. So he went to Congress a number of times, President Adams did, with a bunch of requests. For example, here, this is an address of May of 1797. It remains for Congress to prescribe such regulations as will enable our seafaring citizens to defend themselves against violations of the law of nations, and at the same time restrain them from committing acts of hostility against the powers at war. This is French and British, and the U.S. was certainly being dragged into this. They were certainly under warfare against them from the French for some time, and it was pretty bad. Again, 300 ships seized, and Adams still did not feel that he could just go on a full offensive and take them out unless he had approval from Congress. And here, Alexander Hamilton, during that episode, this is in May of 1798, he's writing a letter to James McHenry, also takes the same position. Adams is left on the foot of the Constitution, unless, of course, Congress authorized something beyond defensive measures, is what Hamilton is saying. He said, any other power than merely to employ the ships as convoys with authority to repel force by force, but not to capture, and to repress hostilities within our waters, including a marine league from our coasts. So the only thing that they could do, even though the French had already seized over 300 ships, probably more by this time a year later, even Alexander Hamilton is saying all they can do is repel force by force. They cannot capture any of the enemy ships. They can only repress hostilities. He said anything beyond this must fall under the idea of reprisals and requires the sanction of that department which is to declare or make war. Again, that's for Congress. And in 1798, in July, Congress, Mike Meharry points out, passed an act empowering President Adams to go beyond purely defensive measures, authorizing U.S. vessels, quote, to subdue, seize, and take any armed French vessel which shall be found within the jurisdictional limits of the United States or elsewhere on the high seas. So Mike makes the important point. Only after this happened did President Adams authorize U.S. ships to engage French privateers with offensive measures. And then back to James Madison as president, even in his message telling Congress that Britain was already waging war on the United States, he acknowledged that Congress might choose not to act. They might not do it, and he was going to follow whatever they had to say. This is kind of a long passage, but it's important. He said, whether the United States shall continue passive under these progressive usurpations and these accumulating wrongs, or opposing force to force in defense of their national rights, shall commit a just cause into the hands of the almighty disposer of events, avoiding all connections which might entangle it in the contest or views of other powers, and preserving a constant readiness to concur in an honorable reestablishment of peace and friendship, is a solemn question which the Constitution wisely confides to the legislative department of the government. In recommending it to their early deliberations, I am happy in the assurance that the decision will be worthy the enlightened and patriotic counsels of a free, virtuous, and a powerful nation. And we also see a similar approach from the Jefferson administration, despite all the propaganda that tells us that Thomas Jefferson waged war or used military force against the Barbary pirates in his first term without even thinking about Congress. You can only say this if you're a total liar or you know nothing about the history, or maybe a combination of the two a little bit. But Jefferson, faced with both attacks by the Barbary pirates, there was already attacks happening, there was already a naval battle had happened, and there was already a formal declaration of war in May of 1801 by the Bay of Tripoli against the United States. He still stayed on the line of defense without authorization from Congress. And here's how Attorney General Levi Lincoln put it. Quote, "Our men of war may repel an attack on individual vessels, but after the repulse, may not proceed to destroy the enemy's vessels generally." So Thomas Jefferson's Attorney General took the position that even after being attacked, you can repel them, and if they run away, you can't even go after them. I mean, that was the most limited view in his cabinet, but just for an example of how that was playing out under the Jefferson administration, which is totally opposite of how almost everyone claims it went down today. So again, despite a battle on the high seas, and despite a formal declaration of war against the United States by the Pasha or Bey of Tripoli, President Thomas Jefferson was firm in his position in his message to Congress in December of that year that he was still unauthorized by the Constitution, without the sanction of Congress, to go beyond the line of defense. That's totally opposite of how the propagandists and the liars and the supporters of the monster state tell us this story. They're either ignorant about the history or maybe they're just lying. But a lot of people do love the propaganda view that all you need to do is call it something other than a war, and the executive branch can do basically whatever they want. But calling a war something other than a war when it's waged without a congressional declaration of war as required by the Constitution does not make it so. And it does not make it anything less than what it really is, which is a gross violation of the Constitution. I know this will not be a surprise to you. You've been lied to about the Constitution. And guess what? That also includes war powers. And from the founders, both in what they said and how they put it into practice, we learn three key points about the Constitution and war powers. One, Congress, not the executive branch, Congress exclusively decides whether or not the United States will engage in war, not the president, ever, not in any case. And war based on that is not just a full-scale invasion, just a single bomb, one drone strike, anything, no matter how limited, is still war under the Constitution. Point number two, the president can unilaterally use the military to respond to attacks, but cannot go beyond the line of defense and reprisals, responding much later on. These are acts of offense, not defense. Number three, even if a war is formally declared on the United States by another country, the president still cannot go beyond the line of defense and must get authorization from Congress to engage in those measures of offense. And in the first four presidents, Washington, Adams, Jefferson, and Madison, all strictly followed these points because the founders and old revolutionaries fought a long, bloody war to secede from an empire where that decision was made by a single person. Man, this is not the kind of thing I was ever taught in government-run schools. I'm assuming almost no one here was ever taught any of this. And that's why we work so hard every single day to reach and teach more and more people about these absolutely crucial principles from the Constitution, from the founders, and how they put things into practice. And you can support us for as little as $2 a month over at 10thamendmentcenter.com/members. It's all spelled out. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way. We also have annual, 5-year, and lifetime options. And if you prefer to make a one-time contribution, or you've already joined as a member and you want to help us out a little bit more, I'm very grateful. No pressure. I'm grateful for any consideration you can give. You can make a one-time contribution over at 10thamendmentcenter.com/donate. It's all spelled out. Again, no pressure. We're going to continue doing this work. We put out all kinds of thousands and thousands of articles and blogs and videos, etc. over at 10thamendmentcenter.com. And we're going to continue doing this work, but we really do need some financial support to continue doing our work and expanding it to more people. So thank you for your consideration. You can also do a number of free and easy peasy things to help us spread the word, primarily triggering algorithms of the mainstream platforms, like leaving comments in the archive, long watch time percentage, like 90% is good, but 130% is awesome on platforms like YouTube. Subscribe, get notifications, reviews on Apple Podcasts, the like. I really appreciate your support and your effort in helping us share this type of a message with more and more people. And more important than that, I hope you enjoyed this episode. I hope it was interesting. This is really deep stuff. So maybe I made it a little entertaining here and there, but more important than anything, I hope it made you think and I hope you learned something. I really appreciate you being here and look forward to seeing you next time here on the Path to Liberty.